All right. Aloha mai kako and good morning, everybody. It is now 9:45 a.m. and we're going to call to order the June 24th, 2026 Land Use Commission meeting. This is a hybrid meeting being held in person at the King Kamehameha Kona Beach Resort, Conference Room 4 at 75-5660 Palani Road, Kailua Kona, Hawaii 96740, and with virtual participation via Zoom. This meeting is open to the public. Please be advised that this meeting is being recorded via Zoom as well, and the recording will be posted to YouTube and used for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. So if you do not wish to be part of the public record, you should exit this meeting now. For those attending via Zoom, please note that the question and answer feature will only be used for signing up for public testimony, and all other communications through Zoom will not be monitored nor made part of the meeting record. Written communications can be emailed to the Land Use Commission office at dbedt.luc.web@hawaii.gov. And for all meeting participants, please speak slowly, clearly, and directly into your microphone. And before speaking, please state your name to identify yourself for the record. We will also share with all participants that we are going to take breaks from time to time, about every hour. Okay, so for everyone, my name is Brian Lee, and I will be serving as the Land Use Commission Chair today. There are 7 seated commissioners. Joining with me today in person is Commissioner Ken Hayashida from Oahu, Commissioner Mel Kahele from Oahu, Commissioner Kuike Kamakea Ohelo from Oahu, Commissioner Bruce Uu from Maui, Commissioner Michael Yamane from Kauai, Commissioner Miles Miyasato from Hawaii, the Big Island. Also in attendance today is the LUC Executive Officer, Daniel Orodenker, the LUC Chief Planner, Scott Derrickson, the LUC Staff Planner, Martina Segura, the LUC Chief Clerk, Ariana Kwan, the LUC Attorney General, Miranda Steed, and again, court reporting transcriptions are being done from this Zoom recording. All right, agenda item number 2 is to consider the remanded petition for a declaratory order for boundary interpretation under Hawaii Administrative Rules, HAR, Section 15-15-22 for certain land consisting of approximately 17.5470 acres situated at 56-102 Old Coast Guard Road. This matter is before the Land Use Commission on remand following the opinion of the Hawaii Supreme Court in Honoipu Hideway LLC, the Land Use Commission, civil case SCOT-24 0000498, which vacated the commission's decision and order and remanded the matter for further proceedings. The remand hearing is conducted pursuant to HAR Section 15-15-100A3. Will the party now, the petitioners, please identify yourself for the record?
Yes, good morning, Chair. Good morning, members, Mr. Ordanker, and to everyone. I'm Cal Chipchase. Next to me is Chris Gooden. We represent the petitioner.
Thank you. Good morning, Mr. Chipchase, Mr. Gooden. Have you reviewed HAR Section 15-15-45.1 regarding reimbursement of hearing expenses?
Yes, Chair.
Thank you. All right. In accordance with HRS Section 84-14, commissioners are not allowed to take any official action affecting a business in which they or a member of their family has a financial interest. They must therefore recuse themselves from this matter if there's any benefit, monetary or otherwise, to themselves or members of their family. Also, in accordance with legal ethical standards, commissioners should disclose any relationship, business, social, or otherwise, that they may have with the petitioner or its representatives or any of the other parties to this proceeding that may give rise to an allegation of bias or impropriety. Do any of the commissioners have any conflicts of interest or disclosures to make? Okay, seeing none. As a reminder, commissioners are prohibited from engaging in ex parte communications regarding pending or future docket matters pursuant to HAR Section 15-15-62. This includes off-the-record discussions with parties, attorneys, applicants, or interested persons during recesses or breaks in the proceedings. To ensure transparency, fairness, and public trust in the Commission's process, all discussions relating to docket matters must occur on the record. During the public meeting, commissioners and parties are respectfully asked to avoid any off-the-record communication concerning matters before the Commission. Okay, let me briefly explain our procedures for today. First, we will acknowledge any written testimony that may have been submitted for the record. We will then open the floor to members of the public who wish to provide oral testimony. After public testimony, we will invite representatives from the county and the state to offer testimony in their capacity as interested governmental entities, not as formal parties to the petition. Next, the staff planner will give a briefing on the staff report that has been posted for this docket. Then the petitioner will be called upon to make their presentation. Following the presentation, commissioners will have the opportunity to ask questions and provide comments. We will then reopen the floor for any additional or new public testimony. Finally, the commission will deliberate on this matter and determine what action to take on this petition. The chair would like to once again remind all participants to speak slowly, clearly, and directly into their microphones. And before speaking, please state your name and identify yourself for the record. This ensures that our transcriber can produce an accurate transcript of these proceedings. Are there any questions now about our procedures for today? Okay, seeing none, as stated on today's agenda, please be informed that the relevant records and documents pertaining to this matter can be accessed for review on the LUC website at luc.hawaii.gov. I'm sorry, luc.hawaii.gov/DR21-73. Before proceeding further, the Commission should address the supplemental filings received in 2026 in this matter following the remand from the Hawaii Supreme Court. Mr. Chip Chase, the Commission will consider whether the supplemental filings received in 2026 may be admitted into the record for purposes of these remand proceedings. And as a threshold matter, please address two things. First, why each supplemental filing is relevant to the issues remanded by the Hawaii Supreme Court. And second, why this material was not presented at the original December 22nd, 2021 hearing. Is there any discussion? Oh, yes, Madam Deputy.
I respond.
Yes. Please go ahead, Mr. Chip Chase.
Happy to, Chair. So the opportunity to rehear this following remand gives us an opportunity to make sure that we have a complete record, to make sure that you get things right, that the Commission reaches the correct decision based on the evidence. Given the time that everyone has invested in this proceeding so far, I think it's going on about 7 years. When we get to the timeline portion, and there's a timeline set out in the staff report, it makes sense to have all the available information and to make sure we get it right. Some of that information we identified after the remand and filed it with the Commission. The specific exhibits that we believe are relevant to the Commission's consideration that weren't part of the original record include the Supreme Court's opinion in this case, which set the standard of review for the Commission. That's Exhibit 40. Exhibits 41, 42, and 52 are public testimony from the last hearing. Exhibits 43 through 48 and 51 are boundary interpretations by this Commission in adjacent or nearby properties in the area, following the rule that we suggest is the rule that the Commission should follow for this boundary interpretation. And so directly on point. Exhibit 49 is a GIS map from the County of Hawaii's real property tax website. Exhibit 50 is the 1974 commission map for Hawaii, North Kohala, which relates to boundary interpretation that followed the same rule that we suggest the commission should follow in this case. Exhibits 4A, 5B, 8A, 8B, 11A, and 13A2 are existing exhibits, but we did TMK overlays so that the properties we're referring to are easier to see on those maps. Those overlays were done with RM Towel, and so we're confident in their accuracy, and we would have a witness testify today if there were any questions as to how those were prepared. So given the nature of the additional exhibits and then the related filings are all just briefings, we believe there's ample reason to accept them and ensure that we have a complete record and an accurate decision today. Thank you, Chair.
Is there any discussion from commissioners regarding acceptance of the supplemental filings into the record? Okay, seeing there's no,
No, that's fine.
all right, no discussions. Okay, so let's see. If there's no further discussion, the chair will entertain a motion regarding whether the supplemental filings received in 2026 shall be admitted into the record for purposes of the remand proceedings.
Commissioner Hayashida, motion to admit.
Okay, it's been moved by Commissioner Hayashida. Is there a second? Seconded by Commissioner Uu to accept. All right, is there any discussion? Okay, seeing no discussion, I'm going to ask the executive director to conduct a roll call vote for accepting the supplemental filings into the record for purposes of the remand proceedings.
Thank you, Mr. Chair. The motion is to admit the additional filings into the record. Commissioner Hayashida,
Aye.
Commissioner Uu,
Aye.
Commissioner Miyasato,
Aye.
Commissioner Kahele, Commissioner Kamakea Ohelo,
Aye.
Commissioner Yamane,
Aye.
Chair Lee.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Okay, thank you, Mr. Odenker. All right, so now at this time, the commission will consider entering into executive session pursuant to HRS section 92-5A4 for the purpose of consulting with its legal counsel on questions and issues pertaining to the commission's powers, duties, privileges, immunities, and liabilities arising from the Hawaii Supreme Court's remand of this matter. This commission seeks legal advice regarding the scope of the remand proceedings, the commission's authority and obligations under the court's opinion, and procedural matters necessary for the conduct of this proceeding. Is there a motion now to enter into executive session and to permit the executive officer, planners, and chief clerk to remain during executive session?
Chair, just a quick question.
Sure.
Would you want to have public testimony first in case they need to go somewhere, or you want to move right into it? Your call.
Okay. Yeah, is there a public testimony before we go into executive session? It looks like there is. All right. Yes, why don't we take it so that we have as much information to consider as possible? Please go ahead. I'm going to swear you in before you testify. Okay, will you please raise your hand? All right. Will you please swear or affirm that the testimony you're about to give is the truth?
Yes.
Okay, thank you very much. Please proceed.
Yes, my name is Linda Halbritter. Aloha, Chair Lee and members of the Land Use Committee. Thank you for taking the time to hear my testimony. I have lived in North Kohala for 45 years. My home is at 56105 Old Coast Guard Road, right above the Coast Guard station. I look down on the pastures between my home and the Old Coast Guard housing. I have lived with my family for decades, and I can remember when the radio antenna in the pastures stood 650 feet tall. I used that red light as a beacon driving home from working at the Mauna Kea Beach Hotel. After the Coast Guard left, things got a little run down. The pasture wasn't grazed anymore, so it got taller and overgrown. The road got bad. It was a complete eyesore. Since Adrian and Nathan's family have owned the property, the Coast Guard has been much better. They worked with the county right away to create the shoreline trail and the public parking for the public. They fixed up all the problems down there, and they helped improve the area too. They helped my son fix the road because it was almost impassable. Even the ambulance didn't want to come down. The potholes hurt my back every day, and I wrote and called the county government to fix it and the road for decades. But together we made a huge improvement for the public. Besides, our home is right next door. I look at the maps and the pictures of quite a while. It was clear that the road on the map does not match the actual road that has been there in front of the Coast Guard housing. And it also is clear to me that the whole coastline from the road to the ocean remains protected no matter what you decide today. I really don't see any reason this map shouldn't be fixed. It is not a risk to the neighborhood or the coast. These folks do everything the right way, and they are trying to get this problem fixed by following the rules. I support this request and hope that you can fix this error. Thank you.
Okay, thank you. Are there any questions for the testifier? Okay, seeing none, thank you very much for your testimony
You're welcome.
today. Well, okay, all right. Yeah, that's it. Thank you. Okay. All right, so now, I think, on the advice of our council, we should go into executive session, but we didn't need a motion for that. And it's just to permit the executive officer, and, and our deputy attorney general and the commissioners to go into executive session. Is there such a motion?
Chair, just procedurally, sorry.
Yes.
No. No other testimony? Do we close testimony?
Oh,
I see none in the Q&A feature on Zoom indicating they want to give additional testimony.
oh, okay. Let's do that then. Sorry about that. Thank you.
No, just close. Yeah, gotta
Yes.
close. Testimony.
Yes, let's take, public testimony.
I have oh, they stopped raising their hand now. If you want to give public testimony on the Zoom, can you use the Q&A feature, please?
Okay, Captain Handyman, you're on. Please offer
Hey.
your testimony.
How's it, guys?
Okay, let me swear you in. Please raise your hand. Do you swear or affirm that the testimony you're about to give is the truth?
Yes, I do.
Okay, please proceed. You have 2 minutes.
Aloha to everyone. For those who don't know me, my name is Jeff Halberter. My mom just gave her testimony. My family's home is Mauka of the property, and we've lived in this area since the days the Coast Guard station was still active. I grew up in a working class family, but was fortunate to be raised in this community that I love and have always been proud to call home. When my family had the opportunity, we purchased land here because we wanted to be part of this community for generations to come. We have now called this area home for nearly 50 years, and this is where I intend to spend the rest of my life. Throughout my career, I have worked as a tugboat operator, a marine surveyor specializing in hull and machinery, ship and cargo damage investigations. Much of my work involved serving as an independent third-party surveyor, evaluating claims objectively and identifying facts and the gray areas to help mitigate and resolve disputes. With that said, because of my background, I understand and respect the concerns being raised about conservation lands. My family has opposed inappropriate shoreline development in places such as Hapuna Beach, Maukona, and Pololu. And I strongly believe conservation land should be protected. At the same time, I believe it is important to look carefully at the gray areas and facts of this particular situation. The structures at Honoipu are not newly developed. They have existed for decades, even before I was born. From my understanding, the current owners are not seeking to expand, but are asking that their existing home be located outside the conservation line, consistent with the majority of the existing structures in the area. Since purchasing the property, they have restored long abandoned buildings that had been and become an eyesore along the coastline. They have taken care to preserve the character of the area, including landscaping with native Hawaiian plants. They have also worked alongside me to helping maintain the old Coast Guard Road, improving that benefit fishermen, divers, surfers, and all others who access the shoreline when the county and state would do nothing. What deserves careful consideration is the inconsistency between the two maps. One map places the conservation line in front of all of the homes along the road, while the other places the line throughout a portion of existing homes. That discrepancy creates uncertainty and a gray area that needs to be addressed by this committee. The map placing the line in front of the home appears more consistent with what exists on the ground today. The alternative map appears to omit certain buildings and veers off the existing road. As a surveyor, I understand that old maps were often created with limited information and were never intended to address the regulatory questions being asked today. Historical photographs from 1960 show that the road and buildings are substantially the same as they are now, suggesting that portions of the map may not accurately reflect actual conditions on the ground. My understanding, correcting this to run along the road would not affect the shoreline, public access, or conservation resources. The area has already been developed, and any future changes would still require extensive review, community input, and major permitting. I understand why residents are protective of conservation lands, and those concerns are mine and are all valued. I respectfully ask the committee to acknowledge the gray areas and consider placing all existing structures along the coastline outside of the conservation area to support and protect of the shoreline we all value. Thank you for your time and consideration and service to our community. Thank you.
Thank you very much, testifier. Is there a question? Okay, Mr. Commissioner Uu.
Aloha, thank you for testifying. The question I have is any other housing structures or structures that would affect, like how it's affecting this specific housing or place or lot? Like you said, the roads were moved, the gray area between the lines. Is there any houses that fall into that category like this one?
Yes, I believe the last two structures The line veers behind them, maybe even a few more of them, but it makes perfect sense to keep those homes out of the conservation area as the rest of them are. So that gray area is basically a line running behind the homes and crossing the road and going behind some of the homes, while another map shows it running consistently in front of all the homes along the existing road.
Thank you.
Okay, thank you. Any other questions for the testifier? Okay, seeing none, thank you very much for your testimony.
Thank you and good luck to
Oh,
all.
is there one more? Is there one more question? Oh, there's one more testifier. Okay. Okay, so we don't have anything else.
If anyone on the Zoom wants to give testimony, this is your last chance. Please raise your hand or use the Q&A feature.
Okay, I don't. Okay.
Seeing none on the Zoom chair.
Okay, and we did have written testimony about this agenda item.
Yes, Mr. Chair, we had 12 written testimonies that have been posted onto the website.
Okay, from the testimony, the County of Hawaii is not here today. They did, however, submit a written statement of no position on February 27th, 2026. State Office of Planning and Sustainable Development, would you like to offer any testimony?
Sure. Allison Cato, Deputy Attorney. Just not bend. Sorry, it doesn't bend. Allison Cato, Deputy Attorney General for the Office of Planning and Sustainable Development. Yes, we submitted written comments back in 2021. But since that time, there has been no change in evidence, and the clarification of the standard of review does not have an effect on the facts and statements in OPSD's written statement. So we submitted nothing further as we have no additional information. Just briefly, based on OPSD's review of the available information, the original intent of the LUC in setting the boundary for this particular property is unclear. There are multiple potential reasons for the LUC's choice at that time, such as preservation of artifacts or conditions, vegetation line or road at the edge of agricultural use, or general 300-foot setback. As OPSD understands it, petitioner believes that if the paved road had been correctly shown on the map, then the LUC would have chosen that paved road as the boundary instead of where the LUC actually situated the boundary at that time. But for the reasons stated in our written comments, OPSD is not convinced that the unmapped road is particularly relevant, or that the LUC's reasons for situating the boundary where it did were somehow incorrect. The current boundary on the 1969 LUC map was a result of various sources of input and the official action of the LUC. And so far, OPSD has not seen enough to say that it is incorrect, as it was officially adopted. We have no further comments. Thank you.
Commissioners, do you have any questions for the Office of Planning and Sustainable Development? Any questions, commissioners? Okay, seeing none. Okay, all right. We've been advised that we should have an executive session without staff. So is there someone that will please make that motion?
I'll make the motion to go into executive order.
Okay, it's been moved by Commissioner Wu. Is there a second?
Second.
seconded by Commissioner Miyasato to enter into executive session with our Madam Deputy Attorney General alone. All right,
Oh, sorry, and Chief Clerk.
and the chief clerk is included, sorry,
For minutes.
for a minute. So, Executive Officer, will you please conduct the vote? Oh, okay. All right, is there any discussion, objections? Okay, let's just have a roll call vote to enter into executive session. All in favor, say aye.
Aye.
Any opposed? Hearing none. Okay, we will return to executive.
Oh, sorry, yes.
Okay, so we will enter into executive session. All right, thank you, everybody. We're back in session and we're gonna call now on Mr. Scott Derrickson to summarize the staff report for us and any staff concerns.
Okay, aloha kako, Chair, Commissioners. I want to start off by saying, you all know that I'm the Chief Planner, the State Land Use Commission. What you should know is that I have over 40 years of professional planning practice and experience. Most of that has been with the state of Hawaii. I'm one of the few people still working for the state that was involved in at least one of the state land use district boundary reviews. The other person is also sitting in this room now with OPSD. I'm a nationally certified planner. I've testified and been considered an expert witness in court here in Hawaii before state agencies, county agencies. And I was consulted as one of the staff planners for this specific boundary interpretation. Okay, for the record, the basis for our position that the existing conservation district boundary on the petitioner's parcel was correctly established during the 1969 statewide boundary review and reaffirmed on the 1974 official map. Our conclusions based on evidence in the Commission's own records as required under Hawaii Administrative Rules, Section 15-15-22, and it reflects the staff's obligation to rely on the official materials that govern the Land Use Commission when the boundaries were officially established. When the state receives a boundary interpretation request, our process begins with the tax map key parcel information that's provided by the requester. We then identify the official state land use district boundary maps that are applicable to that parcel, whether it was in 1964, 1969, and 1974, along with any later commission-approved amendments that might have impacted that parcel. After determining when the boundaries affecting the parcel were set, staff consults with the commission's record, which can include prior boundary interpretations for the specific area, official docket files, hearing transcripts and minutes, historical tax map key parcel books, the commission's administrative rules that were in effect at the time the lines were drawn, and the boundary review reports from consultants, including the 1969, 1974, and the 1990 boundary reviews. These documents form the only evidence that the staff may properly rely upon. We don't reconstruct what should have been done, and we do not base interpretations on new materials that were not before the commission. So I'll talk about some of our central conclusions. The first of which is that the 300-foot setback is more probable than the road-based theory. The commission's 1969 boundary review established 4 conditions in the report for determining conservation district boundaries. One of these, condition number 4, provides that where no clearly identifiable physical landmarks exist, the boundary shall be 300 feet inland of the line of wave action. Based on the Commission's official maps and the 1969 review, staff concluded at the petitioner's location, no suitable shoreline proximate road existed in 1969. The unimproved Jeep trail shown on the 1957 USGS base map, which the Commission used for the 1964 and 1969 maps, turned Mauka, or eastward, before and just about when it reached the petition area, this parcel that's under consideration. Accordingly, condition number 1, using a road as a landmark, did not apply here. The 1969 and 1974 maps show a smooth setback-like alignment along this portion of the coast. The pattern is consistent with condition number 4, the approximately 300-foot inland line, especially in remote areas where no road paralleled the shoreline. This pattern is consistent along the coastline. Where a shoreline proximate road actually existed, the Commission used it. Where the road veered inland, as it did here on the map, the Commission applied the setback. This consistent pattern is visible on the official maps and is supported by the 1969 review, which explicitly contemplates mixed use of the 4 conditions depending on physical geography. The Hawaii Supreme Court has clarified that the preponderance of evidence standard applies here. Staff's position is not merely that the petitioner has not proven its case. Rather, staff concludes that based on the evidence in the Commission's record, it is more likely than not that the boundary at the petition area was intentionally drawn using the approximate 300-foot setback. That conclusion is grounded in the 1969 and 1974 official Land Use Commission maps. The 1969 4-condition framework found in the 1969 boundary review report. And the actual location of the road on the maps used at the time by the Commission to set the boundaries. And the absence of any contemporaneous Commission documentation indicating that the drafters intended to follow the 1961 realigned road. The petitioner relies heavily on non-contemporaneous evidence, such as a 1961 Coast Guard construction photos, a 1965 aerial image, and a 1982 USGS quad map. These documents were not part of the Commission's record when the boundaries were established and therefore cannot override the official maps. By contrast, the 1969 and 1974 LUC maps were legally adopted by the Commission. Hawaii Administrative Rules 15-15-17B as in Bravo, and Hawaii Revised Statutes, Section 205-3, require staff and the Commission to treat these maps as controlling. And there is no contemporaneous documents from 1969 stating that the Commission intended to follow the road at this parcel. Petitioner's theory is therefore not supported by the evidentiary requirements of Hawaii Administrative Rules 15-15-22. Staff has found no evidence that the 1969 drafters made an error in depicting the conservation district boundary. To the contrary, the boundary matches the setback-based pattern shown statewide, where no road aligns with the shoreline. The Commission had multiple opportunities in 1969, 1974, and in 1990 to correct any mapping errors, yet no correction was requested or identified for over 50 years to the present. The Coast Guard and the county also raised no objections to the boundaries at any time prior to this petition. Thus, staff concludes that there is no basis to determine that the official maps contain a mapping error requiring interpretation under Hawaii Administrative Rules 15-15-22F. Based on the official commission record, the governing statutes and administrative rules, and the 1969 boundary review framework, staff concludes by a preponderance of the evidence that the conservation district boundary at the petition area was intentionally drawn using an approximate 300-foot setback from the shoreline, not a road landmark. Staff therefore recommends that the commission affirm the existing boundary and the boundary interpretation done by the commission staff and deny the petition for declaratory order. Mahalo, Chair and Commissioners. Staff is available for questions.
Thank you, Mr. Dirksen. Commissioners, are there any questions for Mr. Dirksen?
Commissioner Hayashida, you said that there's no record that the 1961 road was acknowledged by the Land Use Commission in making the boundary.
That's correct.
And is it likely that when the Land Use Commission makes these boundaries that they are aware that there's houses on Conservation District that they're like conflicting? Because as I understand, there's a house there.
There's nothing in the commission records that supports that.
So there, when was this? There's a house on that property that we're talking about?
There is now.
But it was not in 1969. Wasn't built until before. Wasn't built. What the house was built after 1969.
So the question you're asking is, there does appear to be information that those homes, they're not homes, they were built as barracks for staff that were built back in that time frame. There's nothing in the record, the commission's record, that they used to draw the lines that told them that there were structures there, that there was a road there.
Whose fault is that?
It's no one's fault. The commission used specific maps, USGS maps, at that time that they had in front of them, depicting the geography of the area. Nobody on the record questioned the validity of those maps and pointed out any errors in the maps. The Coast Guard itself, the owners of that property at the time, did not appear on the record anywhere to make any corrections.
Throughout your career, have you come across this condition where there are structures that the commission drew boundaries that made these structures kind of illegal in conservation districts?
Okay. The answer to your specific question is yes. They don't make those structures illegal, they make them non-conforming.
Non-conforming.
Okay.
So that's common.
And there is a process to correct these things. And it's not through a boundary interpretation to move a line. It's a district boundary amendment. If you want to change the district classification, that's the appropriate and correct way to proceed in changing the boundary.
Any other questions for Mr. Dirksen? Okay, hearing none. Thank you very much. Appreciate it. All right, we're now going to ask the petitioner to provide your presentation.
Thank you, Chair. And we have slides to accompany most of the presentation. I'll step back for a moment and acknowledge that the petitioner is titled Honoipu Hideway. It's an LLC. But what it's not evident from the name is that it's a family LLC, and that family is the Egan family. They own the LLC, and the LLC owns the property, and they live there. And Nathan and his wife Adrienne are here today. They are the petitioners. They are the folks that we're talking about, not some, distant company or some entity that resides on the mainland. They reside in those units, those Coast Guard units. The scale of the discrepancy, the error that we believe, is 1.3 acres. That is the totality of the area that we believe was incorrectly mapped in 1969, and the 1974 map simply followed 69. It's not as if it was reevaluated. So we're really talking about an error in 1969 involving 1.3 acres. And the error, stated quite simply, is that a road existed through the property at that time, and the commission did not pick it up because it used a map that did not depict it. But it's quite clear as we go through this, certainly more likely than not, that they were following a road in the area. And despite the small area and the personal nature of this, that it's a family, this has been an incredibly long saga. This is our 7th year working on this petition. That's the process that we've gone through. And it's odd to me because, as you heard from the public testimony, and you saw in this county statement of no position, there's really no one against it except staff. The only opponent we've ever really had is arguing against staff that this is an appropriate correction of a map that was drawn using the wrong landmarks they simply made a mistake on in 1969. And I have deep respect for Scott. Worked with him for my entire career before the Land Use Commission. And so everything he said about his credentials and his experience, I echo. And the rest of the staff, I feel the same way about. But this is an odd one. And so we end up with questions. Commissioner Hayashida asked, did those homes exist? Unequivocally, they did. I mean, that's deeply in the record that they were built in 1961. There's zero doubt about that. And there's no reason to hedge on it. Staff pointed out the 300-foot boundary they believe more likely, as we've shown in an overlay, and we've shown it for 7 years now. It's unequivocal that the boundary line drawn today does not match 300 feet. It simply doesn't. And we'll see that illustrated on the screen. And yet that still remains staff's position. So it's one that has been very difficult for me to understand. And we're asking you today, after this long saga, to finally end it and correct the boundary for this 1.3 acres. So where I'll start is orienting us geographically. And if you look at the map we have on the screen, we're in North Kohala. The Eggins property is the one highlighted in blue. As we go through today, I'll talk about the standard, and then we'll discuss the different options that staff articulated as being the possible boundaries that should have been set, that were meant to be set in 1969. And I'll start by looking at the portion of the land use boundary maps in question. Well, we're all familiar with the land use boundaries, the urban and rural and agriculture and conservation. The lines between those districts are the boundaries. The state land use law was enacted in 61 and boundaries began to be established in 64. The Land Use Commission set the conservation boundary for this area in 1969. And it used to review those things every 5 years, make sure they're correct. Should things be moved in? Should things be moved out? They haven't done that in a very, very long time. But in setting lines for massive areas, right? You're doing the whole state in these reviews. Mistakes happen, right? Everybody makes mistakes. Mr. Gooden next to me points out my mistakes all the time, way more often than I think he should, but they happen. And the question is, can we fix them? Is there a method to correct them that doesn't involve a district boundary amendment? Talk about a process. We've been 7 years on this. A district boundary amendment where we do a full 343 review and then a full petition process before the commission for 1.6 acres. Is that the only method to correct mistakes? No, it isn't. The commission recognized that in mapping these massive areas, mistakes may happen. And the boundary interpretation is the method through which those mistakes are corrected. So how do we describe an interpretation? Well, the Supreme Court has described it for us, and it says this process of district boundary interpretations, quote, functions to resolve uncertainties about the spatial relationship between the LUC map and the land the map represents. It's exactly what we have here. When we last appeared before the commission on this question 5 years ago, we ultimately lost the petition. And we lost the petition because the commission concluded that our evidence was not, in the commission's words, compelling. That was the standard that the commission applied at the time. And so we appealed the decision, and the Supreme Court made clear that compelling is not the right standard. It's a much lower standard. It's called preponderance of the evidence. And so if you're like me, I grew up watching Law and Order, right? So the standard in criminal cases, beyond a reasonable doubt, the highest standard that we have at law, right? No reasonable doubt. We're left with just metaphysical doubt. Okay, we convict the guy. Below that is a clear and convincing evidence or compelling standard that we use in fraud cases, right? So if you're going to accuse somebody of committing fraud, you need to prove that to a higher standard because that's a pretty serious charge. The rest of the time we use a preponderance of the evidence standard. That just means, is it more likely than not? Do we tip the scale, in the Supreme Court's words, just slightly? That's all it takes for something to be more likely than not. It's 51%. The court made clear that that's the standard that should apply in a case like this. Okay, let's come back to the property. And so we've zoomed in on it. This is the property that the Eggans own and have lived in since 2018. The homes, as I said, were built in 1961 when they were part of the Coast Guard Lawrence Station, and they've been in continuous residential use ever since 1961. The petition area only concerns the houses and a small portion of the backyard, just Malka of them. So you can see that area that Mr. Gooden is tracing with the cursor. That's the entirety of the area that we think should have been located or was meant to be located in the agricultural district, not the conservation district. If we look Mackay of that, next to the coastline, that dark area right along the coast, that is a public access trail. And when Nathan and his family bought the property, that trail was fenced off and in disrepair. They removed the fencing, they improved the trail, and they now maintain it. They maintain a 10-foot wide trail by regularly mowing the area, which in this area does get overgrown. And they have worked since 2018 as part of their condition in their county permit and otherwise to improve that trail and improve public access, including by installing public access signs. If we look just down the map a little bit from that to that brown area, that's a public parking area. It's maintained on Nathan's property. It accommodates about 30 stalls. And when the surf is cranking, they're full. I mean, people are there and they're using it. And all of this area that Chris or Mr. Gooden just went over, that all stays in conservation. That all stays in public access. That all stays with the public parking. That all stays maintained by the Eggans at no cost to the public, to the county, to anybody, for the benefit of the public. And so nothing is proposed there, going there, changes there. It's all part of the conservation district. We'll come back to the map. And if you look at this map area, you can see that for this quadrangle, it was based on the 1957 USGS map, and that map itself was based on the 1954 aerial and the field check in 1957. If you look at the thick black line, that's the district boundary separating agriculture and conservation. And if you look at what the line goes over, you can clearly see that it follows the coastal road that existed as depicted on that map at that time in 1957. Those double dashed lines are dirt roads, and that's the boundary along the coast that the LUC in 1969 followed. We zoom in on Nathan's property and put the green border on there so that we can clearly see it. We can clearly see that the road doesn't turn Malco before his property. It actually enters his property. And they drew the line along the road as it entered his property. At the time, in 1957, before the road was realigned, it did turn Malca after entering Nathan's property. But if we look at the course that the LUC followed from there, and we connect it on the larger map, as Chris is tracing it down the coast, they simply drew it in a way that connects with the next point where there was a visible road on the map. There's no cutouts, as we'll see on other maps, where they clearly used a different means other than following the road. There's no deviation in the contour or the course. It simply tracks from road to road across those properties, including Nathan's. That road that was shown in 1957, by 1961 had been realigned. This is an aerial photograph from 1961, clearly depicting the realigned road and the existing structures just Malca of it. Nathan's property is outlined in green, and as you can see, in 1961, 8 years before they drew land use maps, the road did not turn Malca just after entering the property. It turned Malca at the end of Nathan's property. And so the road had been completely realigned. Sorry, it's a 1965 area. We put all of this information together on a composite map. And so you can see the Eggins property in green. You can see the yellow dashed line represents the current boundary as interpreted or as applied in 1969. And as you trace that yellow, you see that it follows the road, the entire course of the coastline, except for notable exceptions that the LUC cited, which we'll see on other maps. But everywhere else we see in this area, it follows the road line. And it follows that road line right into the Eggins property. And instead of dipping in or following some other method, it just crosses it naturally. As we saw in the earlier map, it continues that pattern down the coastline until it adjoins with another road. As I noted at the beginning, the total area then between what we see as the yellow dashed line, the existing boundary, and what we believe is the correct line that would have been the commission's correct line if it had followed the existing physical structures in 1969, is just that small area between the yellow line and the Malca edge of the road that existed. It's 1.3 acres. There's a note in the staff report that suggests it's the full 5.3 that represents the whole conservation district of Nathan's property, but it's not. It's just the 1.3 acres. And then there's a figure in the staff report that tries to depict the area that is the subject of the petition, but it puts the edge of the request at the Mackay edge of the road. And so includes more area than we're requesting and makes a different shape than we have requested. And as I said in the beginning, mistakes happen. And so I understand this was just a mistake, but the actual area is just from the Malca edge of the property. And if you look at the way the line follows from that Malca edge to where it would adjoin the existing boundary line at the end of Nathan's property right there, it forms a perfectly natural curve. There's nothing unusual about that mapping or difficult about the shape that it would create. Okay, so we come to the question. As staff and OPSD ably laid out, there are really three possible options to consider. The first is that the commission intended in 1969 to follow the direction of the road on the map, and it would have set it at that location, even if it knew and had the correct map before it, that the road had been realigned. That doesn't make sense that the commission would follow the actual road features as Scott set out, looking for the features on the ground. In 1969, if it had followed the correct map and knew that the road had been realigned by then, followed actual roadways everywhere else, there's no reason, no indication in the evidence that it would have followed an imaginary road just because it happened to be on the map. Let's see from these other documents, there's no question that the road had been realigned by the time the commission was drawing the map. We've seen the aerial photographs. It's a newspaper article announcing its opening. We actually have a ground level photograph from the road depicting it 8 years before the commission drew the line. So it doesn't seem more likely than not that the commission, but for the mistake, would have maintained a line following district boundary homes, barracks, as Mr. Derrickson said, that existed at the time. And I'll pause there to make one note about the Coast Guard. The Coast Guard, of course, would have no reason to object or comment or say anything else about the LUC's map because the federal government doesn't care what we set down as state land use laws. They're not bound by them. So they can do anything they want. They could have drawn the entire thing in conservation and it wouldn't have affected the Coast Guard's use in any way whatsoever. And so there'd been no reason for the Coast Guard to object, participate, or otherwise comment on the maps when they were done. It brings us to the second option. This is the option that staff has proposed. And staff says that the 300-foot setback from the shoreline consistently and neatly portrays the boundary for most section of coastline that would have been difficult and costly to remap otherwise. Well, we mapped that 300-foot mark. And as you can see, the currently drawn boundary is in yellow, and the 300-foot line is in blue. That's what the map would look like if the commission was following a 300-foot distance from the coastline. It wouldn't have entered the property in the place that it did, wouldn't have been following the road. Remember, the road actually enters the property and is in yellow at the beginning of it. So it would have entered at a different spot and would have curved toward the coast and then bisected an existing building before meandering back down the property. With respect, no zoning body would set a line, a boundary line between district and ag through an existing structure, not intentionally, not without making a mistake. And so it seems implausible, not merely less likely than not, that the commission did not intend to use a 300-foot setback line. The other note on that is that in all the places in this area where the commission deviated from a road or a poly or some feature like that to set the boundary when it used 300 feet, it noted it. It was sort of an exceptional thing, right? Other than the set standards that it had, its default standards, it didn't note when it used a default standard because that's a physical feature in some way. So it's pretty easy to understand. But when it deviated from them, used 300 feet, so not a physical feature, uniformly in every example we've looked at, the commission noted that it was deviating from that standard. There's no notation here. And there's no notation as we go further down the map until it joins with the other existing roadway that the commission was deviating and using 300 feet for this entire area. With respect, it's not more likely than not the commission intended to use 300 feet. So it brings us to option 3. Option 3 is the one that we've presented. We know from the mapping itself that the commission was following the roadways in this area. It did it all the way up the coast, as we can see on that map. We know to a certainty that by the time the commission was drawing these lines, the road had been realigned. And it's unequivocal. And so the only question is it more likely than not the commission drawing a boundary that is following roads would have used the correct location of the road if there had not been a mapping error, if it had used an updated map depicting the road in this location. In every other interpretation in this area that we have looked at, the commission has answered that question, yes. The commission would have and meant to use the Mauka edge of an existing road when mapping the boundary between conservation and land use. And so as we look up the coast, we see all those properties that we've circled. All of those properties were interpreted by the commission as having a boundary that, quote, follows the Mauka side of the dirt road. The only exceptions to that are those two carve-outs for areas of historical significance where the commission expressly deviated from the roadway to make a different boundary. And we can see how pronounced that becomes when the commission intends to draw something other than following the roadway or another natural feature. Look at this property, which is just up the coast from the Agans. We're just very close to their property now. This boundary was interpreted not generations ago, but in 1998, so 30 years ago or so. And when the commission interpreted this boundary, the commission said, we interpret this boundary as following, quote, the Mauka side of the road as it existed in 1969. So not as it might have been mapped in error, not as it might have fallen some 300 foot that we have remarked that we have no evidence of, but follow the road as it existed in 1969. It's a clear, defined physical feature. It makes a very clear record. This commission and every commission going forward, 30 years later now, we know exactly where that road is because we can know exactly where it was in 1969. We'll get one more boundary interpretation. This is east of us, one quadrangle over in Hawaiʻi. This is from 2008, so less than 20 years ago. The work on this boundary involved an interior line, but as the commission described the conservation district boundary for the area, the commission again described it as following the Mauka side of the dirt road as it existed on August 4th, 1969, and the commission was drawing these maps. And so throughout this history, 78, 98, 2008, the commission has consistently focused on this area, on the Mauka edge of the dirt road, and in the recent interpretations expressly noted as it existed in 1969. It makes no sense, not just a preponderance of sense, but no sense that in all of these other interpretations, boundary follows the Mauka edge of the road. The Mauka edge of the road as it existed in 1969, except for the Eggins property. That this one property, 1.3 acres, is the one property when it comes in for an interpretation, it's not interpreted consistently with the Mauka edge of the road as it existed in 1969. Principle one of the guidelines the LUC set out is to follow existing roads, dividing areas between agriculture and conservation. That's what it is seen from the mapping up and down the coast. And when subsequent commissions have looked back at what that commission did and interpreted boundary should fall. They've uniformly set it at the Malka edge of the existing road. So we come back to the standard and our three options. What is more likely than not? What tips the scale ever so slightly? Option one, that the commission intended to follow or to set the boundary at a road that didn't exist as it entered into the Eggins property. It's just coincidental that they then drew it and connected with the road down the way. That's what they intended. That they intended to follow in option two, a 300-foot setback, even though they didn't say so, and they uniformly said so in every other case when they're setting it at 300 feet. And it turns out they set a boundary that didn't follow 300 feet. It doesn't resemble that really at all, except for a small portion of it. That's option two. Or option three, that they intended to follow roads, as was their guiding principle number one, which they did as it entered the property. But because they used a 57 map and the road had been realigned in 1961, they made a mistake and didn't draw that line along the existing road through the Eggins property. I submit that that third option is not only the one that is more likely, but the only one that makes sense. I put up on the screen, as I've mentioned a couple of times, and in the staff report ably sets out, this has been a long journey to get here. Along the way, there's been no convenient assumptions. I think was a notation in staff's report. If we didn't have the circumstance of a road that had been realigned before the map was drawn, 8 years before it was drawn, and clear evidence that the commission was following roads in the area when it drew the boundaries, we might have taken a different path. But because that is the situation, those are the facts, the boundary interpretation is the appropriate means to make that correction rather than going through the boundary amendment process. But it's been a long journey nonetheless. And why have the Eggins embarked on this 7-year odyssey that took us from here to the Hawaii Supreme Court and then back down here? Because this interpretation matters to them, because it makes a difference. Owning a home within the conservation district comes with certain challenges, and the Supreme Court thought enough of those challenges to quote them in its decision, and it corrected the standard that had been applied in the earlier proceeding. And so we've put some of that quotation up on the screen. It affects everything from landscaping to re-roofing to all these other things. Just having that boundary line, that 1.3 acres in the wrong spot, bringing his homes into it. The correction doesn't have any negative effect on the environment, on the people, or on anyone else. As we've set out, all of the areas that should be conservation remain conservation, from the Malka edge of the road toward the coastline, the public trail, the public parking lot, that open space, all of that stays in conservation as it should and stays protected. Interpreting the boundary doesn't authorize new development, doesn't let Nathan expand his house, doesn't take his property out of the SMA, doesn't do anything except correct a mistake that is now 50 years in the making and allow him to operate under for his home, under the agricultural standards. And as you know, we've set out, he does grow and sell fruits and flowers. And that's it. It doesn't do anything else or have any negative impact. And I would say that one of the most telling ways we know it doesn't have any negative impact is the testimony that we received and the testimony that we didn't receive. No one came here today saying that Nathan is doing something bad. There's some written testimony, but none of them showed up. No one showed up to express any concerns except his neighbors who don't benefit from the interpretation in any way. Talk about what he's done on the property since he moved in and the fact that this doesn't have any harm. The other thing we didn't hear is we didn't hear an adverse position from the county of Hawaii. The local government for this area, who has the most interest in the land use regulation for this area and ensuring that its coastlines are protected, ensuring that its standards are followed, took no position on the petition, didn't even come today. If it had any concerns, you know they would have expressed it, right? Director Darrow is an excellent planning director. We would hear from them and we would hear why this doesn't line up. They're planning what they think we're wrong, why, whatever it is. But they're not here today because they recognize that there's no harm in moving this boundary to align with where it should have been set in 1969. So we come at the end here to the request. We're asking the commission to adopt a motion to grant the petition and interpret the boundary as it existed in 1969. This is shown on Exhibit 19. As you can see from that exhibit, there's nothing awkward or strange about the boundary that we set. There's nothing unclear or uncertain. It resolves it not only today, but for all future commissions. It keeps the homes in the agricultural district and keeps all of the coastal area in conservation. And it's entirely consistent with the same phrase and the same interpretive terms the commission has used in previous matters. All we're asking is to be consistent with those matters and interpret the boundary, follow the road that actually existed when the boundary was drawn. Thank you.
Okay, thank you, petitioner. Yes, 2-minute recess, please. All right, we're coming back into session, and what we're going to do is we're going to take public testimony. I think there's one public testimony, and then we're going to break for lunch, and then we'll come back and we'll have questions for the petitioner. Okay, let's have the public testifier come forward. And I'm going to ask you to raise your hand and swear you in. Okay, please raise your hand. Yeah, oh, you can sit down. Yeah. All right. Okay, do you swear or affirm that the testimony you're about to give is the truth?
Yeah.
All right, thank you. Please proceed, yeah, with 2 minutes testimony.
E mele komo a he mele aloha. No nā kupuna I ka au I hala. Aloha mai kako. Aloha, my name is Cindy Freitas. I'm a native descendant of these lands prior to 1776. The commissioner's duty extend beyond the survey of the map dispute. While the petition is presenting as a boundary interpretation matter, the commissioner's obligation do not end with determining whether the historical maps support one boundary location over another. The Hawaii Supreme Court has constantly held that the state agency must independently protect Native Hawaiian rights, public trust resources, and cultural practices whenever government actions may affect the land and natural resources under Article 12, Section 7. The commissioner has a constitutional duty to protect all Native Hawaiian rights. Article 1, Section 1 and the 7 of the constitutional laws, the Kapa'akai analysis, which is the Kapa'akai Oka'aina versus Land Use Commission, PASH versus Hawaii County Planning Commission, the Water Use Permit Application Waiole Ditch, Kauai Spring Inc. versus Planning Commission of Kauai, Ching versus Case, and Pele Defense versus Patty. For this reason, I respectfully request that the commissioner deny the petition unless and until it can make specific findings demonstrating protection of Native Hawaiian rights public trust resources, culture, practices, and conservation values the district was created to preserve. Mahalo.
Thank you. Any questions for the testifier? Okay, seeing none. All right. Thank you very much for your testimony. So now we are going to take a break for our lunch and then house, let's see, it's 11:45, 12:30. Is that enough time? Is that enough time? Okay, 12:30 it is. Okay, everybody, we're back in session. I think at this point, we're to clear up some of the issues. I have a bunch of questions I'm going to ask of staff as well as the petitioner for everybody's. So for staff, is there anything about the 1974 map itself, the scale, conflicting lines that's actually ambiguous or which is independent of Honoipu's historical argument?
Sorry, could you
Yeah,
ask that
sure.
question again, please?
Is there anything about the 1974 map itself, scale, conflicting lines, that's actually ambiguous here, independent of Honoipu's historical argument?
No, from the staff standpoint, no. That map was accurate, and that is what the commission at the time used to reiterate the official boundaries.
Okay. Was the 1969 report's four-condition framework applied consistently along this whole stretch of coastline, as in Figure 3, or only in the isolated spots?
The staff believes that it was consistently applied. The isolated spots, I'm not sure what you're specifically referring to there.
Okay. Is there any nearby parcel where a road was used as the boundary landmark? And if so, what distinguishes that location from this one?
So the 1969 boundary maps did follow the roadway as it was portrayed on the map. Where the road deviated on the map, the commission used another standard. They did not have a roadway to follow on the map. That's the evidence that's on the record. That's what the commission used.
Okay, is there any contemporaneous documentary evidence, not staff inference, of why this 1969 drafters chose the setback over the road here?
No, staff looked at, again, as I alluded to previously, the methodology that we utilize when we're trying to do the historical research. We looked at transcripts, we looked at meeting minutes, we looked at the maps themselves that were voted in by the commission in 69, 1974. And there is nothing on the record to specifically indicate why the commission chose to place the boundary exactly where they did. But the evidence on the record, the fact that they approved the map with that line, is what's on the record. They did not follow a road that was not on the map at that time, 1969.
Okay, how does this case differ from Stengel, Castle Foundation, and Honolulu, where the LUC found actual documented evidence of a manifest drafting error before granting?
So in each of those cases, there was, again, historical research done, and at least in the Stengel case, there was reference to following a top of poly. And in that case, the line deviated from the top of poly. So in that instance, there was the ability to make an adjustment based on facts on the record.
Okay. Mr. Dirksen, did the Coast Guard as the facility operator ever show awareness of the boundaries location in any record from 1969, 1974, or 1992?
No, again, there's nothing on the record, no evidence on the record that the Coast Guard ever had any concerns, brought up any issues, or attempted to provide information to the commission, putting it on the record that there was something incorrect, that there was a roadway that the commission hadn't known about.
Okay, just a couple more. For the burden of proof, is it the staff's position that Honoipu's theory is merely not proven, or that staff's setback theory is affirmatively more probable?
I think the staff's position is that our position is affirmatively more probable based on the actual map that the commission at the time approved, using the features on the map as depicted.
Okay, is that more likely setback for efficiency explanation based on contemporaneous records, or is it staff's own plausible historical narrative now?
I guess I'll go back to that. There's nothing on the record that explains the specific line that was drawn across the property there and slightly to the south, because the map that they were using in 1969 did not show a roadway that they would have been following. So they followed an approximate, not exact, but approximate 300-foot setback from the shoreline.
Okay, and finally, does anything in the late filed exhibits today change the staff's analysis, or is it cumulative?
Staff thinks that the additional information that was late filings is primarily cumulative, but there's also information there that, again, is not contemporaneous, meaning it wasn't of the record before the commission in order for them to make the decision in 1969 or to reaffirm it in 1974. So the fact that there's evidence on the record, it was put onto the record by the petitioner in this case. It wasn't before the commission previously, and the commission did not have it when they set the boundaries in 1969, and again, reaffirming them in 1974.
Okay. Commissioners, any questions or concerns for Mr. Dirksen?
Commissioner Hayashida, how the council brought up two boundary interpretations, 1998 and 2008, I believe. How is that similar or different than the condition we're discussing today?
Okay, both those boundary interpretations precede my time at the commission. At that time, I was with the Office of Planning as a planner. As those, my understanding, and I can be corrected, but neither of those boundary interpretations came before the Land Use Commission. Those were both determinations made by staff and approved by the executive officer at that time. So the language in there came from the staff.
It's my understanding of what was presented that they moved the line back to the roadway. Is that what you understand?
What I understand is that the staff did a boundary interpretation And they identified, based on looking at the 1969 map and the 1974 maps, that the boundary in those, across those parcels was intended to follow the roadway as depicted on the map in 1969.
One last question. Council also provided a interpretation of the 300-foot setback from the coastline on their map. Do you agree with that? Because that doesn't, I mean, the line they drew is way outside of that line.
So I believe what petitioner's counsel was showing us was a 300-foot delineation from the coastline that was identified in their shoreline, certified shoreline meets and bounds description. And as you saw, it was an irregular line. It wasn't a smooth line. And it was intended to follow 300 feet from different portions of the shoreline itself. When the commission did their maps, and we can see it across all the islands in the state, in the areas where they were following a 300-foot setback, it wasn't an exact setback. They're doing this on these large USGS maps, and it does follow the coastline, but it doesn't exactly follow the coastline, and it's not exactly 300 feet from the coastline at any point. The commission at 1969 did grapple with the concept of where is the coastline, and they did not have a definitive answer at that point in time.
Thank you.
Any other questions for Mr. Derrickson? Yes, go ahead, Mr.
Mahalo, Chair. I just have a
Mark,
follow-up question. The 300-foot setback, that's just the minimum setback? Or is that a hard line that delineates the conservation and agricultural zones?
So because this is already in the record and it's referenced multiple times, this is the 1969 State Land Use District Boundary Review report by consultants hired by the commission. They didn't approve this report like they approved the maps, but they utilized the information in these reports to guide them. So the 300-foot setback is one of the 4 guidelines to utilize in setting the map boundaries. So as guidelines, they normally would try to look for specific geographic features to lock in the line. Where they didn't have that, they usually defaulted to either a top of poly, which was not a perfect delineation, and an approximate 300-foot setback. So it wasn't a hard and fast line, exactly 300 feet. And we see that in the maps. So you can't infer that the commission meant exactly 300 feet when they were setting these boundaries. They utilized an approximate 300 feet offset from the shoreline. And what we can see in the maps themselves that they approved is that that line does not always exactly follow the ins and outs of the coastline. It's a general line.
Mahalo, Chair.
Thank you. Any further questions for Mr. Derrickson? Okay, if not, thank you very much. I do also have some questions for the petitioner. So counsel, just for clarity on the acreage, is it 0.525 of the original 5.319 acres carved out as an erosion area in 2021 and isn't part of this petition? Can you confirm? everyone's working from the same current figures, so new findings aren't ambiguous about what's actually being decided?
I can confirm it's 1.3 acres. It's simply from the existing, currently depicted line, I should say, to the Mackay edge of the roadway, which is surveyed to be 1.3 acres.
Okay. All right. And then, setting timing aside, is there anything in the 1974 map itself that's ambiguous, or this entirely a map reflects the wrong place argument?
Well, I don't know if there's anything else in the 1974 map that's ambiguous. I've been focused on this one portion of property. It's certainly possible that there's other mistakes that were made along the way, and we've seen other corrections, right, up and down this coastline. And on that point, it wasn't, you know, is the colloquy with Mr. Derrickson, just to be clear, the 98 and 08 interpretations were not as depicted on the map. That's not the determination that was made. It was as existed in 1969. And so they interpreted to align with the physical existence of a roadway. And I think we're consistent with that. So if you mean the 1974 map that depicted those areas that were later corrected, yeah, there are other errors that are part of it. But it's important to remember that that 74 map just duplicated the 69 map. So what we're really dealing with is the 69 map, because that's when the boundaries were drawn. And as we've seen up and down the coast, yeah, there were areas that needed to be corrected. Whether they're corrected by staff or they're corrected by the commission, doesn't make a difference. This could have been corrected by staff. Staff disagreed, and so that's why we're before the commission. But the error is the same.
Okay, what contemporaneous evidence, not inference, shows the 1969 drafters intended to follow the road at this specific location?
Yeah, absolutely, Commissioner, Chair. Flip the one with the... We'll go back to some of the maps that we looked at earlier. So this is the 1969. I think, Chris, you'd have to get permission to put it up again.
Council, we have distributed the PowerPoint to everybody, so you can just reference the page. Yeah.
Chris, what page is this? Exhibit 4A, and it's page 4 of the PowerPoint. So Chair, if you look at the map that we put up on the screen, right? So we looked at this earlier. You see that the commission in 1969 is specifically following a roadway in delineating the boundary. And it follows that roadway all the way into the property. So we know unequivocally the commission in 1969 was following the roadway that it thought existed in that location into the property, not north of it, but into the property. So that no inference is required. We know that to a certainty. They were following a roadway. And we know equally certainly that the roadway they were following had been relocated 8 years earlier. And so they were simply following the wrong location of the roadway. We put those two things together, no inference is required. They literally are showing us they're following a roadway. And we literally know they were following the wrong one into the property. That's a mapping error. And that's what this process exists to correct.
Okay. If the boundary went unchallenged for over 50 years through 3 reviews, including by the Coast Guard, what explains the silence?
Yeah, absolutely. So let's come back to a couple of things. One, it's not 3 reviews. It's 1969, and they just duplicated on the 74 map. And then the commission itself stopped reviewing the boundaries, right? The law changed. Later went to OPSD, has the responsibility to advise if there are any map corrections, but you don't do your 5-year reviews anymore, which is why these boundaries have been static for so long. That's one. 2, the Coast Guard owns it. We know not only from this proceeding, but you just read the news about the leased lands or anything else, the federal government is not bound by state land use laws. They don't care where you set the boundary. And so there's no reason for them to say anything about where the boundary is set. They can continue to do it wherever they want. The whole thing could have been conservation and it wouldn't matter to them. Why would they get involved in it? No reason. It matters now to the Eggans a lot. And the Eggans have been working on this since 2019. And that's a long time to work on 1.3 acres.
Okay, Mr. Chip Chase, if the commission concludes that this is a boundary amendment question, what is your position on pursuing relief under HRS 205-4?
I guess my position would be why. So in everything that we heard from staff, from OPSD, from the county, which was silent, no one has said this area should be in conservation. Right? Nobody has said this is an area that we want to preserve in conservation because it meets all those values and we can't appropriate to be moved. None of that has happened in this proceeding or any other proceeding over the last 7 years. So everybody acknowledges that this doesn't need to be in conservation. The question, this 7-year fight has become about process. Somehow the process has been interpreted not to serve the people to whom the substance affects, the Eggans. So we've elevated this process over anything practical because no one believes this needs to remain in conservation, at least nothing that anybody's ever said before the commission in any form whatsoever. So my position would be this process, the one the Eggans have followed, exists to correct these boundaries. We've seen it up and down this very coastline. Why on earth would you make them go through an entirely different process, a process that exists to move big areas into different districts for development purposes? Why would you make them go through that process, correct an error, follow the wrong that's been corrected elsewhere in the same coastline for 1.3 acres when they don't intend to develop or do anything different from it? Why make them follow that process? Why elevate that process over people?
Okay, and just a few more final questions. Why would the drafters have used the road as a landmark here specifically, given that it veers away from the shoreline just north of the parcel?
We could pull that back up, but to correct that, it doesn't veer north of the parcel, it enters the parcel. And so they follow the road into the parcel, literally into the parcel. At that point, as we saw from the bigger map, they just draw a line that roughly tracks to the next road so that there's a neat alignment. That's what they did. Since they were following a road, we know that into the property. We know they were following a road into the property. We know that if they had been aware they were following the wrong location, that they would have put it in the right location because we know they were following a road. Why would they follow the wrong location, knowingly follow the wrong location of the road and connect it up with the road down the coast from there? When they intended to use something other than a physical landmark, the 300 feet, as Scott explained, they said so. They said so that everyone would know we're doing something different here. You won't find this line on the ground. We're doing something different. They said so. They did not say so here.
Okay. How can the 1982 USGS map establish 1969, 1974 intent when it postdates both maps by years?
Oh, we've never ever said the 1982 map shows the intent in 1969. I mean, that would be silly. We've never said that. We've illustrated, right? The 1982 map illustrates the location of the road. It depicts it. It's just showing you for visual purposes where it is. But as you saw in our presentation today, all of the evidence that we did was contemporaneous, right? It all predated 1969. It existed prior to 1969. That's contemporaneous evidence.
Okay. And then finally, if the error is as apparent as claimed, Why did no one, including the Coast Guard, raise it for over 50 years?
Yeah, no, I understand, Sharon. This goes back a little bit to my discussion earlier in our colloquy a moment ago. There was no reason to raise it when it was owned by the Coast Guard. I mean, like I said, where the Coast Guard doesn't care. The Coast Guard simply doesn't care. And the Land Use Commission stopped reviewing its boundaries, right? You guys just, by statute, stopped doing it. And so there was no reason anyone would identify or catch the error until you had a private party identified. And you know, I had the wonderful opportunity to talk to one of the public participants here, not one of the witnesses, or testifiers, but one of the participants on a break. And the if we were here in a situation where you didn't have clear map evidence that they were following a road, and you didn't have a clear historical evidence that they just followed it in the wrong location, this wouldn't be the right process, right? There'd be a different process for this, and it might be more time consuming. Hard to imagine anything more time consuming than this has been, but it might be, right? It might be even more difficult than we've gone through on this. But we do have those things, and that's why this process exists. And whether the Coast Guard didn't care doesn't matter. The owners today found it, followed the process to correct it, and it does meaningfully impact their use and enjoyment of the property. This mistake all these years ago, it's never too late to fix a mistake, right? We have a chance to fix it today.
Okay, thank you. Folks, any final questions for either staff or the petitioner?
Chair, I got two questions.
Please proceed.
I got two questions for the petitioner. You have decided on doing a boundary interpretation instead of a boundary amendment. What, I mean, wouldn't that resolve your problem in whatever you're planning on doing with your property? You know, I'm just kind of good. I think you were asked the question.
100%, Commissioner. I totally understand where you're coming from. And if the Eggins had a crystal ball and they knew that 7 years ago when they asked staff to correct this location, as staff had done up and down the coastline for decades, if they had known that it was going to take 7 years and a trip to the Supreme Court, maybe that would have been a better path for them. But they set out on the path that had been well worn up and down this coast. And having come this far in it, I think we should see it to the end rather than start a new one.
You know, and in my opinion, the petitioner is being well represented by an excellent attorney here. One more question. When the purchase of the property that included 4.7 acres, I believe, of conservation, was he aware that there was all these restrictions? Conservation, this is what I need to do, Kapalkai analysis, probably what environmental impact statement. So now after years have gone by, after the purchase been made, I guess there's something that he wants to do with the property. He wants to avoid going through this whole process of going through the Kapalkai and an EIS.
No, so I mean, excellent question. My no is not there. Good question. When the Coast Guard abandoned the property, there was a historic review done, and we have that in evidence, and we could pull up the slides if we need to. It was determined that no historic properties, Malka of the roadway, would be impacted, and that's really the area we're dealing with, is an existing structure, so fully what the law would call fully developed property, and in evaluation, there's no cultural historic concerns in that area, this limited area of the petition area. So it's not to avoid or get out of that or avoid any cultural impacts or concerns. The cultural, especially access for fishing, hiking, gathering, any of that would occur, makai of that, in the area that is and would remain conservation. The second part is to the idea of an intent to do anything with the property. Absolutely not, right? If in order to develop the property, you'd have to move it into an urban district here. You'd need community plan and general plan and zoning and all of those things. Nobody has asked for any of that. This isn't an adjustment or an amendment to move it from conservation to urban. It's agriculture. It's agricultural land and it's agriculture Mauka of that, and they're engaged in agriculture. And so there's no intent to do anything different or to develop the property in any way that this would make it different or easier to get there. What this deals with is the day-to-day obligations and requirements of living on a property. You live on a conservation property, any trees with a diameter over 6 inches, you need state approval. If you need state approval to change your landscaping, your total coverage, including paving stones, are regulated by OCCL. All of those things add a layer of challenge when you're a homeowner, particularly a homeowner on the coast. And if it were merely that it's challenging, that's not a good reason in and of itself to do this. Absolutely. That just explains why they've gone through this process, why it matters to them. The good reason for doing it is because a mistake was made, and we should correct that. And that mistake makes their life easier is great, but that's not the reason for doing it. The reason is to fix the mistake.
Thank you.
Thank you.
Mr. Chair. Thank you, Mr. Chip Chase. Just wanted to kind of follow up on that question.
Totally.
Like, this line has been there for 50 years. Like you said, it's a small sliver, about an acre total. And I guess your client is here wanting to move that line, but you're saying because it's a mistake, but I mean, still, what instigated that? You didn't just go over and said it's a mistake. Obviously, there's some benefit of what you want to do, trying to do, continue to do, that's going to make things easier if this line is moved.
Oh, yeah, absolutely, Commissioner. And I've tried to be clear about that. So I think if we take a step back, so the Eggins got an SMA approval to renovate the historic structures, remediate the asbestos and all of those things in 2018. Enormous cost. As part of their process in doing that, they identified this mistake, this mapping error, that they'd clearly intended to follow a road, but the road existed in a different location at the time they did it. And that started them on this journey in 2019. The why, well, and I'll take one more step back. Recognizing that the boundary should have included the existing structures up to the Mauka edge of the roadway in the agricultural district doesn't let you do anything different with the property. You're still subject to Chapter 205, in particular 205 2. I think it would be, I don't think this is, well, some parts of 4.5 might apply. But it's still a highly regulated property. It doesn't allow for development of additional structures or uses other than a farm dwelling for residential. All of those limitations still apply to the property. So it isn't to do any of those development related things. It is what I said, that day to day, do I need to re-roof my property? If my property is in conservation and I have to re-roof it, I not only need the county's permission, I got to go to OCCL and get permission to do that kind of work on my property. If I want to change my landscaping in certain ways, I got to go to OCL to get permission to do those things. You don't have to do that in agriculture. In the agricultural district, you can use your property, still subject to county laws, still subject to state use requirements, absolutely. But in easier ways is probably the best way for me to put it.
Is there like associated costs to do those additional items that you mentioned, going through like a process, additional process costs?
Absolutely, every time.
Thank you, Mr. Chair.
Thank you. Any other questions for the petitioner or for staff? Yes, go ahead.
Mahalo, Chair. This question is for the petitioner. And it's a simple question. Did the Land Use Commission of 1969 draw the maps and the lines based on the information and evidence that they had at the time?
They did it based on the information, it appears, that was before them, not based on the information that existed at the time. And that's the mistake.
So you claim, right? So I have a follow-up question, Chair, if you may.
Yes.
On the map that you showed and the southern property where you claim that the intent of the LUC was to connect both roads, is that road within the 300 feet setback?
I don't know. We haven't mapped it down there, but
So could the intent of the LUC also be to follow the 300-foot setback in that southern property?
no, Commissioner, with respect, that would be a very difficult conclusion to assume. They followed one or the other guidelines, not all of them. So the 300 wasn't a minimum that they followed, it was an alternative. When they didn't have a physical feature, they defaulted to 300 feet. So not as a minimum, but as an alternative. And that might be closer or farther than the physical features they followed in lots of places. The second thing is when they did follow 300, everything we've looked at says when they did follow 300, they said so. Because you couldn't find 300 as a physical feature on the ground, they took the extra step of telling us that's what they're doing. They didn't always do that when they followed a physical feature because you could find the physical feature. And so there's no evidence anywhere that they were setting it according to both. That would be contrary to their guidelines. Or in those locations, they were following 300 feet.
So is there any evidence that the LUC did not follow the 300-foot setback within the petition's parcel?
Yeah,
in
absolutely.
discussion?
Absolutely, Commissioner. As we've shown on the map, they literally followed what they believed to be the correct location of the road into petitioner's parcel. So that's one piece of evidence. We know they were following that as their default. They did it up and down the coast. Two, we know where 300 feet would be from the coastline. And we know that the boundary, even at the entry point, doesn't follow what would be 300 feet. And three, they didn't tell us they were following 300 feet. And again, everywhere they did, they told us.
Okay, so particularly in this parcel, did the LUC show any evidence of them telling us that they're following the road within this parcel of discussion?
On the map itself, Commissioner, as it literally follows the road as they thought it existed into the property.
But through their property? Is there any evidence that indicates that the LUC intended to follow the road through the property?
Well, they follow the same course where the road starts to the end, and then as we've shown, down at the bottom. So you can see physically on the map what they were following and what they connected to. In between those 2 points, if they're going to deviate and follow some other rule, in all the other instances that we've looked at, they say so and say we're no longer following physical features. We're going to follow 300 feet. This would be anomalistic to be the one place where they followed one line, the road, into the property, and then they just suddenly changed and said, we're going to follow something else now, but we're not going to tell you what that is. We're going to leave it for 60 years for somebody to figure it out. That doesn't seem likely.
What time now? I have a few more questions, but I'll yield back the time because I want to make sure that we can conclude.
Does anyone else have any questions? If not, then we're going to let Commissioner Vice Chair proceed and finish up. Okay, I don't see any other questions.
Mahalo. Again, this is for the petitioner. Is it possible that the LUC could have been following the vegetation line?
No, Commissioner, it's not possible.
How do you know that for a fact?
Because that is not one of their standards set out as their guidelines for setting the boundaries. And secondly, the vegetation line would be much farther Mackay because it would represent the high wash of the waves. And we know that this shoreline, the vegetation line and the high wash of the waves are substantially more Mackay than any line that they drew or we've suggested they should have followed.
Okay. You made quite a bit of conclusions in your presentation earlier. One of them that the potential changing of this zoning will not have any environmental impacts. But how can you make that determination without any 343? Absolutely,
Commissioner. Absolutely. And so I think that there's two points to it if I can. The first is affirmatively, right? We know the structures exist. They've existed since 1961, the roadway too, although the roadway would stay in conservation. The structures would be part of agriculture. Those aren't changing. They were renovated and following an SMA permit in 2018 with all the SMA considerations that we review, which substantially do concern the same environmental and ecological impacts that we look at through 343. So we know that full review was done in 2018, and we know that it was approved and that the structures were renovated. We know that use will continue. So there's no development associated with correcting the line, and there's no new use associated with correcting the line. So there's no change in any existing condition, which is what we would look at for a 343. Is there a trigger? Are we doing something different that might substantially or have a substantial adverse effect on the environment, including all the considerations that make up our human and natural environment? Nothing is changing. So we know affirmatively that there won't be any impact because it's the same today as it will be tomorrow. The second, in all this long proceedings, 7 years of proceedings, no one has ever come forward, staff otherwise, suggesting that there's some environmental risk in correcting this line for 1.3 acres. So we know affirmatively nothing's changing, and we know on the negative side, nobody has ever suggested otherwise.
So, Chair, how much time do we have? Just a time check, sorry.
Probably 15 minutes. We can ask more.
Yeah, how much time do you want for deliberation?
Probably a half hour.
Okay, so I'll move on to start with. And you know what? Mahalo for responding.
Anytime, Commissioner.
Chair, I'll just yield back the time. That way we can make sure that we hit the other points on our agenda as well.
Okay, thank you. All right, well, I'm sorry?
Yeah.
Yes, that is true. Okay. We can. So this commission will now conduct formal deliberations to consider the remanded petition for a declaratory order. I will note for the parties and the public that during the commission's deliberations, we will not entertain additional input from the parties or the public unless those individuals or entities are specifically requested to do so by the chair. If called upon, I will ask that any comments be limited to the question at hand. Commissioners, let me confirm that each of you has reviewed the record, including the transcript and exhibits from the December 22nd, 2021 hearing, as well as any materials properly admitted into the record as part of these remand proceedings, and are prepared to deliberate on this matter. After I call your name, will you please signify with either an aye or a nay that you are prepared to deliberate on this matter? Commissioner Hayashida.
Aye.
Commissioner Kahele.
Aye.
Commissioner Kamakeo-Hello.
Aye.
Commissioner Miyasato.
Aye.
Commissioner Uu.
Aye.
Commissioner Yamane.
Aye.
And I, Brian Lee, am also prepared to deliberate on this matter. All right, commissioners, the chair will now entertain a motion, and then after that, we can have more discussion. If there is a second. Does anyone have a motion?
I'll make a motion.
Okay,
And I'll make the motion, then I guess we can discuss it later. I request the motion to grant the petition and interpret the boundaries following the road as it existed in 1969.
okay, is there a second?
Commissioner Hayashida, second.
Okay, it's been moved and seconded. Discussion, please. Go ahead, Commissioner Wu.
Yeah, and to be fair, I kept an open mind in listening and kept an open mind what staff had to say, what everyone had to say, really. What I come to conclude that humans make errors. Just is that simple. I've been on both sides of the discussions. I've been on the planning commission where we change the community plans, general plans. I've been on the private side where they mistakenly rezoned properties. And properties that people owned for 130 years, but did not know it was rezoned. And part of this huge process to zone lands or makeup of lands in creating these boundaries, you set by guidelines and you set by timelines. And I only can give you the example based on GPAC, general plan. It goes before the GPAC committee, then it goes to the planning commission, then it goes to the county council. Although it might be separate, what you guys do, the process is the same. It's humans making decisions for a vast majority of land that encompasses everyone on island, and not everyone pays attention. But within that large project or large job that you have in front of you, there is timeline set. And I never was happy with the information being given to our community to make a better decision or to have the residents who's been affected involved. So when you say, how come the Coast Guard didn't know? I think Cal answered it pretty good. But I want to tell you something. People who owned the land for 130 years had no idea they were zoned incorrectly or zoned without them knowing until they went about doing their normal everyday business. So it doesn't matter if you bought it or not. I believe the interpretation in what you guys doing is the remedy to handle the stuff that falls through the cracks, because it will. I'm an example. My family land was an example of that. So when we said at the beginning of this process, and if this had anything to do with Hawaiian rights, I am Hawaiian, but it does not affect the shoreline. In fact, not only do you guys have shoreline access, you guys get beach parking, which is what I can not say for a lot of the shorelines I attend to. I forgot, I lost my chain of thought, but the people that affected, we found it out on Maui, it was Hasegawas and Motukuji Church in Paia. They got affected by things happening to them without them knowing. And I just felt like, even though we following this process that was created by humans, things will fall through the cracks. This is the out for fix it, right? We're not looking at fixing the entire process, because I said 95% of the process is correct, but you're gonna get that 5%, like our family and our neighbors, that fell through the cracks. And we the ones suffered the process in dealing with this process. And I thought it was an unfair process, to be fair. But for the 95%, you're great. I mean, if this is not your property, we all can agree it's pretty good, right? Like, we good, right? And then we can believe in the process because it didn't affect us. But it doesn't matter who owns the property, right? Until you're a property owner, like myself, or like my neighbors in Paia who got affected by that. So, and again, go back to the beginning. I kind of remember my chain of thought. 51%, we gotta believe, right? There's 51 preponderance is what we're looking at. I don't know who got who on what, but it's a 50-50 going in on a balance. But after hearing to what I heard from both sides, I would say the 51 goes higher than 51 on my part. That's my 2 cents to 51%. Thank you.
Okay, thank you. Who seconded? Was it Miles? Oh, Ken, Commissioner Hashi, do you have any comments?
I support Bruce on his, we're gonna have shortfalls in our process, and it seems to me that this is one of the shortfalls, and that the roadway was the intended line.
Okay. Yes, Commissioner.
I'd just like to add one more thing, that I absolutely respect everyone's decision, including our staff's decision, to do and propose whatever you have to do. This is just my mana'o sharing with everyone else, with respect to everyone's mana'o.
Thank you. Any other discussion? Commissioner Kamakeo, hello? Or
I'll go ahead, let you finish.
Okay, Commissioner.
Hey, Mr. Chair. Yeah, so what I'm hearing is a line that I didn't think was a mistake. I think was the process was used to determine at the time to develop that boundary. And even though the petitioner says it's a mistake, but it was only brought up to benefit the client. So if there was no client to benefit from it, this line would still go on being the line that was used based on the process, whether it's a combination, hybrid, whatever the thought was, that was the line. And to move it because someone benefits, individual benefit, I think that sets a dangerous precedent going forward that anybody can go, oh, if we move this line 100 feet, we don't need to do this. We save this much money. We don't have to do that. So, I'll be opposing this motion based on that thought. Thank you, Mr. Chair.
Okay, thank you. Commissioner Kamakeo, hello.
Mahalo, Chair. In the petitioner's exhibit 1, page 7, if you go all the way down to the 4 major conditions that have been recognized and recommendations based upon these conditions, the LUC has determined the conservation district boundary. The petitioner assumes, that the LUC followed the physical demarcations under 1, and it's highlighted within the exhibit. But my question earlier about could the LUC of 1969 follow the vegetation line? If we look just under, in number 2, it says right here, where a vegetation line such as a windbreak or a row of trees more clearly marks the edge of the agricultural practice, this was used. That's where I hold my line. Because I'm out to that area. Just a stone's throw away at the Botello's property I was raised. I am out to the coastline. As a cultural practitioner sitting here on this board, I must say, that kilo and observation matters as well. So therefore, I will be voting against the motion. Mahalo, Chair.
Thank you, Commissioner. Any other comments or questions?
I got a comment,
Yes, go ahead.
Chair. We put faith in our staff, the LUC staff, and hopefully they've done and I believe they've done a great research and going back and presenting all of the evidence. I kind of agree with my fellow commissioners here. The landowner knew that they were buying conservation land. They knew that there was going to be restrictions. If there was no improvement planned, I don't believe they'd be here at the Land Use Commission. They should have gone and did a boundary amendment. And I know it's probably pricey, probably costs more than $80,000-$90,000 to do an EIS. But I think that's a venue that they should have taken. With that being said, I cannot support the motion. Thank you.
Okay, thank you very much. Any other final comments?
I have a final comment.
Yes, go ahead.
Mahalo, Chair, for the opportunity to share again. I want to commend the petitioner. 7 years is a long time. And I understand, the harm and the eha that may cause you folks, and this is nothing personal against you folks. So really, if there's a better process, then I'm 100% willing to hear you again. Mr. Chip Chase, you argue a great case. Excellent. So, I really want to commend you folks. Again, 7 years is for some folks a lifetime. So hopefully we can find some resolution for this ohana.
Okay, well, if there's no further discussion, then Mr. Ordenker, will you please conduct the roll call vote?
Thank you, Mr. Chair. The motion in front of the commission is to grant the petitioner's Request and follow the road as it was delineated in 1969. Commissioner Wu.
Aye.
Commissioner. Oh, sorry. Commissioner Hayashida.
Aye.
Commissioner Miyasato.
No.
Commissioner Kahele.
No.
Commissioner Kamakeo, hello.
Aole.
Commissioner Yamane.
No.
Okay, it's moot then.
Chair.
I'm not gonna vote since it's moot, so.
Okay. What? The vote count right now is 4 noes and 2 yeses.
4 no's and
2 yeses.
you have to vote. We can 5. So either way, you can vote however you want. But you need to vote.
Okay, because it's not gonna pass, right?
No, I will if you. Well, it depends how you vote. Depends how you vote.
No, wait. Okay, but it's 5 against, right? It's 4.
4 against.
4 against. Well, it doesn't matter how I vote, you know.
It does. The AG is telling you to vote.
Okay, I'm gonna say no.
Thank you, Mr. Chair. The motion does not pass with 5 noes and 2 yeses.
What other motion could there be?
To deny.
Oh. Okay, is there anyone who wishes to make a motion to deny?
Chair, this is Quike.
Yes.
I move to make the motion.
Okay, is there a second?
Chair, I second.
Okay, it's been moved and seconded. Is there a discussion on denying? Okay, hearing none, please conduct the roll call vote.
Thank you, Mr. Chair. The motion is to deny the petition. Commissioner Kamakeo, hello.
Aye.
Aye.
Hey, you know, and Chair, if I may, I just want to make one small comment. You know, this is really no laughing matter, and out of respect for our petitioner, yeah, if we can just minimize or limit, you know, our chuckles on this end of the line, and let's conduct ourselves with aloha.
Yes, this is a difficult thing.
Commissioner Kahele.
Aye.
Commissioner Hayashida.
Nay.
I'm sorry, I'm correcting my math here. Commissioner Miyasato.
Aye.
Commissioner Yamane.
Aye.
Chair Lee.
Aye.
Who did I miss? Oh, Commissioner Uu. Yeah, got it.
Nay.
Okay. Thank you, Mr. Chair. The motion carries with 5 affirmative votes.
Okay, thank you. I'm sorry. Thank you. Appreciate it. Yep. Thanks. Yeah, let's take a short 5-minute recess. All right, is there's anybody from the public that would like to make any additional testimony on this next agenda item?
You choose.
Okay,
You should be on page 8.
I'm on page 10.
We already did testimony. We're on adoption a minute.
Oh, okay, sorry about that.
Yeah.
All right. Thank you, everybody, for your patience. The next order of business, agenda item number 3, is the adoption of the minutes and approval of the May 13, 2026 and May 14, 2026 meeting minutes. Ms. Kwan, has there been any written testimony as received on those minutes?
No, Mr. Chair.
Okay, are there any members of the public wishing to testify on this item?
Nobody on Zoom used the Q&A feature to indicate they would like to provide testimony on this item.
Thank you. Commissioners, are there any corrections or comments to those minutes?
Chair Squeaky.
Yes, go ahead.
I will Honolulu and not participate in the vote.
Okay, thank you. Yes,
Mr. Chair, I also recuse myself from that meeting, so I won't be voting on the approval of this minutes.
okay, thank you. All right, no.
Motion to approve?
Yes.
Second.
Yes, motion has been moved by Commissioner Miyasato, seconded by, Commissioner,
Also absent, Chair. I don't know if you have.
No,
Okay, we only have 2 abstain. Did you not review them?
No, absent.
or you can still,
Do we have to defer?
I guess so.
Yeah, sure.
Yes, we'll have to defer them. Someone has to review them before the next meeting then.
So if not everyone had a chance to watch the YouTube or review the transcripts to confirm the minutes are accurate, we'll have to defer the item.
Chair,
Yes.
just quickly, my reasoning for Kanalua is because I wasn't present, but I did review the record.
Oh,
So if you would allow, if I could withdraw
yes,
my Kanalua, that way we can get to the business at the moment.
yes, sounds good. All right, so you withdraw and then will someone make the motion to approve the minutes?
I believe the motion's going through already.
Okay,
It was
I second it.
and I had a second.
okay, moved by Commissioner Wu, seconded by Commissioner Kahele. Can you conduct, okay, any objections? Hearing none, by acclamation, the minutes are approved by voice. Okay, next agenda item number 4. The next agenda item is the election of the commission officers for fiscal year 2027, covering the period of July 1st, 2026 through June 30th, 2027. At this time, the commission will consider the election of officers for the upcoming fiscal year. The positions include chair, vice chair, and second vice chair. We'll now recognize any written public testimony submitted in this matter. Ms. Kwan, has there been any written testimony submitted on this matter?
No, Mr. Chair.
Ms. Kwan, are there members of the public that wish to testify on this matter?
Nobody on Zoom used the Q&A feature, Chair.
Okay, we'll now open the floor for nominations for chair.
Chair, I nominate Commissioner Lee.
Okay, thank you. Are there any additional nominations for chair? Okay, hearing no further nominations, nominations for chair are closed.
Mr. Chair, oh, sorry, Mr. Chair, I'd like to nominate Kuiki for chair.
Kuiki, do you accept?
Chair, I accept the nomination.
Okay, it's been moved. So we have 2 nominations then. Okay, so we just conduct a roll call vote? Okay, is there a second for Kuiki?
Chair, I would second this.
Okay, it's been moved and seconded. All right. Okay, so will you conduct the roll call vote, Mr. Odenker?
Thank you, Mr. Chair. The motion is to elect Koike Kamakeo Hell as chair for the upcoming fiscal year.
You have 2 nominations, huh?
Yeah, we got.
Are we doing one person and the other?
Yeah.
You can call a name.
Yeah, can someone,
And you just call the commissioners and have them take a name?
I guess, can someone just move for one of them?
Oh, we have Koike's been moved for.
Okay, then let's just do it that way.
Okay.
We had one earlier too, right?
Yeah.
Me and Sofia nominated. You have a nomination. Yeah.
Yeah, we have 2 nominations.
Okay, so we have 2 nominations. Did one of the nominations get a second? Who seconded?
For-
For Brian Lee.
Okay.
Okay, so vote on Lee. Vote on Lee first? Yes. And
Okay,
then if we pass, it's okay. If he doesn't pass, then.
Okay.
Yeah, gotcha.
okay, was moved by Commissioner and seconded by, oh no, who moved, Misato and Misato. Okay. The motion is for Commissioner Lee to be elected to a term as chair for the upcoming fiscal year. Commissioner Miyasato.
Aye.
Commissioner Uu.
Aye.
Commissioner Hayashida.
Aye.
Commissioner Kahele.
Do you have the votes? Nay.
Commissioner Kamakeo, hello.
Green, but, yeah.
Oh,
Mahalo for your leadership, Brian. And, let's just take a chance at this. I'll hold it.
Commissioner Yamane,
Nay.
Chair Lee.
Aye.
We have 4-3 vote.
Okay, so it doesn't pass then.
Okay.
So now to the second question.
Thank you. The motion is to nominate or to elect, thank you. Elect Koike Kamakea Ohelo as chair for the upcoming fiscal year. It was, let me see who was, Commissioner Yamane,
Aye.
Commissioner Kahele,
aye.
Commissioner Miyasato,
Aye.
Commissioner Hayashida,
Nay.
Commissioner Kamakeo Ohelo,
Green. Aye.
Commissioner Uu,
No disrespect, nay.
Chair Lee.
Again, no disrespect, nay. Okay.
Okay, debate each other. Yes.
Wow.
I know that Commissioner Kamakea Ohelo would do a good job, but I think I'll be here and I would love if you could serve as vice chair and continue on. And I would want Makahele for second vice chair unless someone else wants to be, but we'll defer to the wishes of the commission.
Chair, I feel both of you would do an excellent job. So I did vote for both of you. I just, for me, I think, with no disrespect to nobody, I like seniority to take precedence. So that's where I stand.
Mahalo for the opportunity to share, fellow commissioners. Chair Lee, just, you've driven us this fiscal year through a lot of turmoil and maybe, some super controversial topics, items, things. And I just mahalo you for your leadership. I was on the fence to serve again a second term on the LUC. And the reason why I'm here is to ensure that the voices of our kupuna and our kupuna aina are represented. And with that being said, as long as I'm on the commission, I can ensure that I'll be here to malama that role. So whether or not, I take the chairmanship, I deeply respect and honor each and every one of you colleagues here on the LUC commission. And what Commissioner Miyasato said, about seniority, I respect that. So mahalo nui for sharing your mana'o. And while I hold no degrees, I'm here representing the pedigree of my ohana and my kupuna, and all of the practitioners that have invested and instilled within me, and all of my lived and life experiences. So mahalo again for the opportunity to share. Whether or not I'm chairman, I will be here to serve. You can count on that.
Mr. Chair, I just wanted to kind of voice my reasoning for nominating Kuiki. On our KAC board, I got two former land use commissioners. Leo knows them well. They're senior people that I respect. And one of them always told me the commission is here to be the safety net because everybody has access to developers, to money, to people building houses. But when you get down to the people, the community, they have no else to turn, and they turn to the land use commission. And Kuiki, in tough situations like today, that's where he's grounded it. And that's why I think, no disrespect to Chair Lee, but just think going forward for the next 4 years, that's the kind of leadership you want, facing tough decisions, making sure that the people, the community have access and have their voices heard versus just high-paid lawyers. People can afford these people, consultants that can talk fast and talk good. And, we kind of get like, oh, wow, yeah, that's the right thing to say. But like Kuiki has shown the leadership, he's going to listen to the people. I think that's what this commission is about, is a safety net for the community to be heard. Thank you, Mr. Chair.
Thank you. Any other thoughts?
Chair, I just want to make a statement.
Sure.
You and I go back, I don't know, 30 years. We've always represented the blue collar, the working class, and no disrespect, but Ohelo and I have become, close allies in representing the Native Hawaiians, and I think you would do a good job in taking us to the next several years as chair. As far as seniority, I kind of put age before knowledge, and I think Kuiki would do a better job as being the first chair. Thank you.
Chair, if I may, I just want to clarify, this is only for a single fiscal year, correct? And then this time next year, we will be deciding again, right? Like if we got to change course or not. So, it's not for the next several years, and that in itself is a huge commitment. But just to clarify for the record, this is only for the next 12 months.
Yes.
Oh, my error, sorry.
Yes. Okay, so that would be, so you're accepting for second vice chair then, Commissioner Kahele?
Oh, reaching.
Well, only if Mr. Ohelo decides on taking first. If
Yeah, I
not,
think
yes,
that's
I'll
a
accept it.
conditional, yes.
Yes.
So,
And there's no term limits, right? Or 1 year.
oh, you could be forever. No, I think everyone here is capable of doing a good job, and we all bring different perspectives from our different islands, as well as from our past history and what's brought us to this point. And so I think we have a good balance with our staff. I think we're always learning, and we learn from each other, and we learn from our executive director as well as our deputy attorney general to do things the right way. And I think we all see that sometimes the decisions can be very tough, but I appreciate everyone's commitment. And so we're going to try and keep everyone's time and commitment in mind, including staff, as we go ahead in this year. And thank you to OPSD as well and members of the public. So I guess, do we vote again?
Yes,
Okay.
motion.
Okay, so we need another motion then for chair. Somebody's got to make a motion. Yes. I think.
Commissioner Hashida, make a motion for Chair Brian Lee.
Okay, it's been moved by Commissioner Hashida. Is there a second?
I'll second.
Okay, it's been moved and seconded. Hopefully no discussion, so let's conduct the roll call vote.
Thank you, Mr. Chair. The motion is to elect Commissioner Lee to the chairmanship for the next fiscal year. Commissioner Hayashida.
Aye.
Oops, okay, Commissioner
Aye.
Commissioner Yamane,
No.
Commissioner Kahele,
Aye.
Commissioner Kamakeo Hello.
Oh, Ole.
Who am I missing? Commissioner Miyasato.
Aye.
Chair Lee.
Aye.
Did I miss somebody? 1, 2. Oh, that's 7. Okay. 1, 2. Commissioner Kahele, your vote was,
I'm sorry.
what was your vote again? I'm
My
sorry.
vote was aye.
Um, So the motion carries with 5 affirmative votes.
Okay, and then now I would like to make a motion for first vice chair for Commissioner Kamakea Ohelo.
Second.
It's been moved and seconded by Commissioner Wu. Is there hopefully no discussion or acceptance from Commissioner Kamakea Ohelo?
I gladly accept.
Thank you. Okay, if no further discussion, let's conduct a roll call vote for first vice chair.
Commissioner, the motion is for Koike Kamakeo Hello to be the first vice chair for the upcoming fiscal year. Commissioner Lee,
Aye.
who was the second? Commissioner
Aye.
Commissioner Yamane,
Aye.
Commissioner Kamakeo Hello,
Aye.
Commissioner Kahele,
Aye.
Commissioner Hayashida,
Aye.
Commissioner Miyasato.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Okay, and then for second vice chair, make a motion for Commissioner Melkahele.
I second.
Okay, it's been moved and seconded by Commissioner Wu and accepted by Commissioner Kahele. Please conduct the roll call vote.
Thank you, Mr. Chair. The motion is for Commissioner Kahele to be the second vice chair for the upcoming fiscal year. Commissioner Lee,
Aye.
Commissioner
Aye.
Commissioner Miyasato.
Aye.
Commissioner Hayashida,
Aye.
Commissioner Kahele,
Aye.
Commissioner Kamakeo Hello,
Aye.
and Commissioner Yamane.
Aye.
Thank you,
Okay.
Mr. Chair. The motion passes unanimously.
Thank you. Great. Once again, is there any member of the public who wishes to provide any new or additional testimony on this matter? If not, then Ms. Kwan, are there any members of the public who wish to provide new testimony on this matter?
Seeing none in the Q&A feature, Chair.
Okay, thank you. Item number 5, the next agenda item is the protocol for executive officers' performance evaluation for fiscal year 2026. This next agenda item is a discussion regarding the protocol for conducting the executive officer's annual performance evaluation for fiscal year 2026, covering the period of July 1st, 2025 through June 30th, 2026. Commissioners, do you have any questions? Okay, seeing none. I have a Excel form that the staff updated, and I'm gonna ask Commissioner Kamakeo Hello if he will be the one to collect the commissioner evaluation. So they'll be sent by Ariana to all the commissioners, and then we'll have until the next meeting, prior to the next meeting, to send everyone's evaluation to the first vice chair for him to collect and average out the different scores, and we'll review that. And I'll be in discussions with Commissioner Kamakeo Hello on how that will proceed.
Can you provide a deadline when they're due?
Okay, I guess the next one is July 15th, right? So let's see, that's not that much time. So just a couple of weeks. Yeah, July 10th. Okay.
Mr. Chair, I would note that we will have a new commissioner on board by that date, who may,
You may not yet decide to participate.
but he should be contacted.
Okay, okay, sounds good. All right. Okay, the next Land Use Commission meeting is scheduled for July 15th and will be held in Maui. So due to the demanding schedule required to complete LUC business, I would like to request that meals be provided as a working lunch as an integral part of that meeting. Mr. Odenker, will the LUC staff please make the necessary arrangements for this working lunch?
We will be sure to do so, Mr. Chair.
Great. This concludes our meeting. Is there any further business to discuss? If not, we declare this meeting adjourned. Thank you, everybody.